A new patent reform proposal is making its way through Congress. The Senate version of this reform, Bill S.23, is a stripped-down version of the Patent Reform Act of 2009 and 2007 that never got any traction in the Senate. Although slightly refurbished and renamed as the Patent Reform Act of 2011, it is old news. But if enacted, it will be bad news for all American innovators. That's why American Innovators for Patent Reform is opposed to the Patent Reform Act of 2011, and here's why. President Obama, in his recent State of the Union speech, spoke extensively about winning the future through innovation. The president continued his innovation mantra in the speech he delivered when he presented his proposed federal budget on February 14, stressing the need to invest in innovation and new technologies. But how do we square the president's newfound commitment to innovation and R&D with the destructive legislation that has just been introduced as the Patent Reform Act of 2011? President Obama speaks of winning the future, but the future can only be won by making sure that American businesses, universities, and independent inventors have access to an efficient patent system that produces strong patents. Although the White House and Senate are both controlled by Democrats, they are totally out of sync on this important issue. Although the president did not mention the Patent Reform Act in his State of the Union address, Patrick Leahy, the Senate Judiciary Committee chairman, announced that he shared President Obama's commitment to preserve America's role as the global leader in innovation. Yet on the same day, Leahy introduced the Patent Reform Act of 2011, which will actually stifle innovation in this country. As executive director of American Innovators for Patent Reform, I was disappointed to see several bad ideas, fixtures of past patent reform proposals that failed to be voted into law, keep showing up along with a few new bad proposals. For example, this proposed legislation introduces a new mechanism to challenge the validity of issued patents, post-grant review. We already have two procedures to challenge an issued patent. Post-grant review is a third, more expensive re-examination proceeding that will not be affordable to many inventors, small businesses, and universities, many of whom will be forced to abandon their patents. How would that add to patent value or aid innovation? In the United States, patents have always been awarded to the first to invent rather than the first to file inventor. If two inventors file for patents on substantially the same invention, the patent will go to the inventor who can prove that he or she was the first to invent it and was diligent in reducing it to practice. In other countries, a patent is awarded to the person or entity that is first to file the patent application. As a result, inventors rush to patent offices around the world with skimpy, half-baked applications. The Patent Reform Act of 2011 proposes to change the traditional American first-to-invent system to the foreign first-to-file regime. Under this proposal, the patent would be awarded not to the first inventor, but to the winner of the race to the patent office. It is not difficult to see who would benefit from this reform. Large corporations, with their armies of in-house lawyers and deep pockets, will get a head start on the race. And small companies, universities, and independent inventors will be put at a distinct disadvantage. This would not be a fair race. The Patent Reform Act also proposes to appoint judges as gatekeepers to prevent juries from slapping an infringer with a large settlement. At best, this is moot, as judges already act as gatekeepers, routinely slashing jury awards. This will further devalue patents and discourage patent owners to sue infringers. How does that promote innovation? Once again, lobbyists for large corporations who drafted this bill are trying to rig the game. If this bill is made into law, it will be virtually impossible to prove willful infringement and, as a result, obtain triple damages. At best, this is also moot, as the courts have already adopted insanely high standards for proving willfulness. However, if enacted, it will benefit infringers and promote more litigation. since infringers will be no worse at the end of litigation, win or lose, than at the beginning, so why settle? The Patent Reform Act of 2011 is not about promoting innovation. It is about stacking the deck in favor of the infringers. It is an anti-innovation proposal that must be voted down. President Obama speaks of investing in R&D and making our nation more competitive. The Patent Reform Act of 2011, spearheaded by Obama's fellow Democrats, threatens to weaken patents through post-grant review, weaken patent rights by making it easier to infringe and harder to prove willful infringement, and make it more difficult for smaller entities to patent their inventions. And to top it all off, inventors will have to pay more in fees when the Patent Office would have more than enough funding if only fee diversion were ended and the Patent Office was allowed to keep all the fees that it collects. We encourage you, we implore you, to write or email your 2 U.S. senators and tell them to vote no on Senate Bill S.23, because it will neither reform nor improve the U.S. patent system. It will not make America more competitive, and it will not aid job creation. The future of our country lies in innovation. Let's not tinker with a system that works. Please visit our website for more information about this patent legislation and other important innovation issues.